The trial is almost over. All the witnesses have stepped down, and the exhibits are logged. Now it all comes down to the closing argument. This is your final chance to speak to the jury before they deliberate. We are going to build a complete, adaptable closing argument outline, and we'll cover the physical delivery techniques you need to stand confidently in that room and win your case. Step 1 happens long before you stand up. You must have a concrete theory of the case. This is a summary of exactly what the evidence has shown, distilled into 1 or 2 clear, impactful sentences. Step 2 is tracking the actual evidence. You can only talk about witness testimony and exhibits that the judge admitted during the trial. You cannot base your closing on what you hoped the evidence would show. Because live courtroom rulings are unpredictable, committing to a word-for-word written script is a trap. If a key exhibit is kept out by an objection, a fully memorized script suddenly falls apart in front of the jury. An adaptable outline lets you adjust on the fly and survive the reality of the trial. Every effective closing argument follows a strict 3-part anatomy: the introduction, the body, and the conclusion. Moving into the body requires mapping out the specific elements you must prove. Connect your key legal issues directly to the witness testimony and exhibits supporting your side. Before you present that structure to the jury, you must follow strict courtroom etiquette. When it is your turn, stand up out of respect, wait for permission, and always say, "Your Honor." Once the formal introductions are out of the way, immediately deploy your theory of the case as a hook. Tell the jury exactly what the evidence has proven right at the top of your speech. Combining strict procedural respect with a rapid, theory-driven hook instantly establishes your authority. It anchors the jury's perspective, so they view the rest of your argument through the exact lens you want them to use. Many attorneys fall into the Hollywood risk. They rely on theatrical, overly complex legal jargon, thinking it makes them sound smart. In reality, modern juries find highly scripted, jargon-heavy language suspicious and alienating. Direct, plain English builds credibility. Instead of saying, "the preponderance of evidence suggests," tell them it is more likely than not. Speak clearly and formally, but talk like a real person. Next, you must construct your sentences using past tense affirmative statements. State the facts as they happened, and never phrase your arguments by negating the opposing counsel's claims. This is based on how human memory works in a courtroom. If you say the defendant didn't run the red light, the jury often loses not and just remembers the phrase "ran the red light." Instead, say the defendant came to a complete stop at the signal. Stripping away the jargon and exclusively using affirmative phrasing ensures the jury remembers your client's story exactly as you intend. You prevent any accidental reinforcement of your opponent's narrative. Every case has weaknesses. You have to identify your bad facts and address them head-on. If your witness has a criminal record, bring it up yourself instead of hiding from it. An advanced technique to contextualize these bad facts is using rhetorical questions. Ask the jury, did he hesitate to admit his past? And should we ignore the facts of this accident because of something that happened years ago? As you build these arguments, remember the strict procedural rule. Your closing can only reference exhibits and witness statements that the judge officially admitted into evidence. When you reference an admitted exhibit, physically hold it up. Use rhetorical questions to guide the jury toward a specific logical deduction. Ask them, where was the boy when he was struck? He was right here, in the crosswalk. Volunteering bad facts and tying arguments directly to physical evidence builds unshakable trust. It positions you as the most reliable, objective voice in the room. As you transition out of your evidence review and into your final paragraph, you need to clearly restate the legal burden of proof for the jury. Remind them exactly what threshold had to be met. Then you deliver the ask. You must tell the jury exactly what verdict they need to return. Do not leave this implied. Never end your closing argument with open-ended questions or vague philosophical statements. Asking a question at the very end allows the jury to come up with answers you might not want. Delivering a definitive, confident ask removes all ambiguity from the deliberation room. You provide the jury with the exact roadmap they need to rule in your favor. Now finalize your preparation. Convert your drafted argument into a bulleted outline on a legal pad or clipboard. This prevents your notes from flopping around and allows for a natural, conversational delivery. Establish your physical baseline. Stand up straight and keep your shoulders back to project absolute confidence. Avoid slouching or fidgeting. When engaging the jury, step out from behind the podium if the rules allow. Move to an optimal distance of 5 to 10 feet away and make deliberate eye contact with the jurors to educate them about the case. This diagram shows how to use your gestures deliberately. If you point to opposing counsel, use a harder, accusatory tell gesture with a pointed finger. When referencing your own witnesses, use an inviting, open-handed give gesture. Even with your outline, you must completely memorize your introduction and conclusion. This allows you to deliver the most critical moments of your speech with zero notes and unbroken eye contact. Combining a highly adaptable, evidence-based outline with a commanding, deliberate physical presence gives you the ultimate formula. You transform a standard speech into a winning courtroom verdict.